Hi everyone. Hi Patrick. So we start with the session. This is the last session of the day. We had a very interesting discussion with the other previous session. So right now, while we wait for the other speakers to join, I would just like to introduce our speakers and moderator for the session. For our moderator, we have Patrick Desmond. He's a special counsel at SCG Chemicals Co. Limited, Thailand. And we have our speaker, Sonja London, Counsel, Licensing Executive, and Secretary to the Board of Directors at Tactotek, Finland. We also have Abdullah AlFarha. He's the Senior Legal and Corporate Governance Advisor at Saudi Telecom Company, Saudi Arabia. And for the other speakers, while we wait for it, let me just introduce the name. His name is Samit Gambhir. He's the Vice President and Company Secretary at DCM Shriram Limited, India. So right now, I would hand over this session to Patrick.
Okay. Can everybody hear me okay, right? All right. So listen, we are here to talk a little bit about how to value IP, but I think that the title of our panel session is a little bit misleading. It's sort of maybe reaching out and saying, okay, how to develop cost accounting methods for manufacturing. This is it'd be something that would take at least 1 or 2 semesters at a university to really nail down and then just begin there with kind of experience. So what we'd like to do is share with our audience is to let you know that IP can be valued, but there's a lot of different methodologies that can be used. So the takeaway we hope to get across to everybody that's listening and here is that when it comes to valuing IP, if you get 20 different people in the room, all IP valuation experts, you could probably come up with 20 different values, depending upon what methodology they use. The thing you want to do is when you value IP is pick your methodology, decide why that was a good methodology, why it makes sense. Is there a rational basis for why you picked it? And point out to whoever you're trying to show that this is the value, why you did what you did. And if you're in a situation where you have a competing interest, let's say you're in litigation or you're in a licensing deal, the other side is always going to pick out a methodology too, and each parties are probably going to pick out a methodology that's most favorable to them. You have to look for the basis for the rationality and why they choose what they choose. So what we're going to do today is we had a couple more speakers, but unfortunately they couldn't join us at the last minute. But there's 3 of us here, and we're each going to share an experience with you where we actually had to value IP on a real live transaction. Our company was counting on us to get it right or to make sure that the mitigation was maximum. And I'd like to start the meeting with Sonja London. She'll introduce herself, but she's going to talk a little bit about a deal that she had where she was licensing the value of technology and a patent. So, Sonja, one of the things that made me curious about your subject matter was, that you differentiated a patent from technology. So, I hope you when you talk a little bit about your experience, you could tell us a little bit about how you see the difference between a patent license and technology license and how you might value those differently. So go ahead, Sonja.
Okay. Now that we have a good time here, since we have less speakers, let me start by introducing kind of a little bit of background of where I come from. So I'm a lawyer, and I have not been doing valuation of IP from technical perspective, but purely from, let's say, licensing and commercial perspective. I have a long background in licensing SEPs from Nokia in Nokia. So this meaning standard essential patents. And I have been building and creating patent licensing programs and then executing on those programs later on. So I have a fairly good touch on kind of what works in the market for patent licensing. Now, however, I'm working for a technology licensing company called Tactotek, which is a Finnish developer and licensor of structural electronics. So how do you put electronic components inside an in-mold plastics? So this is a very complicated technology, and our company does technology licensing, so it's not pure patent licensing only. So couple of points that I'd like to make about this. One is about contextual valuation. Valuation depends on context. And then one is about pure licensing, pure patent licensing when you are creating a licensing program and kind of considerations in there. And then a little bit of, let's say, comparing that patent licensing program to technology licensing program. So couple of points on the contextual valuation. As we all know, a patent is a right to exclude others from making, using, selling, or offering to sell the technology. And this exclusion does not happen automatically. So patent has a limited or no value if the owner is unable or unwilling to enforce the patent to exclude others. So this, to put it in context, the right of exclusion has value when the owner exploits the technology herself and excludes others effectively, or the owner is able to license others, or the owner is selling a patent to someone who does the exploiting or licensing. And then there's one more case that I could come up with, is that if there is an entity or someone who is doing either exploiting, licensing, or selling, and that entity acquires the whole patent owner, which is, for example, for small and medium-sized companies, this is an opportunity. And this means that when the right to exclude has value, it is depending on context, and then the monetization of that IP or that patent depends on the valuation that depends on the context. So would the patent have value if the owner is a startup that has no ability to enforce, or would there be a value for a buyer of that patent or that buyer of the startup who would have ability to enforce? So that's kind of the first point here, is that the value of an IP is contextual. Now, then the second point, when you are thinking of creating patent licensing program, and this is pure patent licensing, so payment for not getting excluded, getting a license to practice the patents. And how do you value them, or how do you value the program? I take this patent valuation as part of the program is kind of a building the commercial context for the whole program. So first you need to, of course, start with analyzing the patents and knowing what you have. You need to know the patent scope, the application area of that patent technology in general. You have to know whether the patent is used. You have to understand the geography, of course, where the patent has been filed and granted, and so on. And then you may be better able to explain the kind of the technical strength and relevance of the patent. But for me as a lawyer, it means that if the patent is hard to design around, then it's fairly good for licensing. If it's an optional way on doing something, or if it's easy to design around, then of course it doesn't have that much of a value for licensing, for example. Then, of course, if it's not only a patent, but there's a patent portfolio, then you need to understand the same things for the whole portfolio, what kind of product scope it is covering. And kind of, okay, now we understand the technology side, and we understand the patents, what do we have? Then we need to analyze the product market. Which products do use the patents? If there are no products on the market, there's no licensing program. So no value for the patent from licensing program point of view. But if there are products on the market that use the patent, then you can start to kind of create the program around those. You need to understand what is the value of this technology to the products that are using it. Are they in the core? If you don't, for example, if you have a mobile phone, there's little value for that phone if you cannot make phone calls. So then those connectivity patents that allow you to make phone calls, they are pretty valuable, for example, because you need those patents to be able to practice the core functionality of the product. So the technology value for that kind of thing would be high. How much the market can bear a cost for those technologies. Even if the value is high, you can't charge like all the world for those patents. You have to take into account the product and the product value and how much people are willing to pay for such a technology in such a product. What is reasonable royalty? You have to think about that if you are licensing standard essential patents. Kind of, you need to understand how many products are on the market, what is the value of those products, what is the value of the technology for those products, and then you come into understanding of what would be the royalty, for example, for that patent or patent portfolio. Who are the key players? Is it fragmented market? Can you license most of the market with one transaction, or do you need thousands of transactions to get a meaningful share of the product market licensed, for example? And then finally, you get into something that what would be the expected royalty income or the licensing income for those patents. You might think about how many years you have left on the lifetime of the patents. Is the portfolio developing? Is it fixed? And then you can calculate that kind of a lifetime, expected lifetime times the market size times the expected royalty per product, and then you get a total, and then you net present value that. So it's kind of a mathematical thing. Of course, you need to think about what is the investment that is needed to get to that licensing income. Will you need to invest on a team doing this? Will you need to invest on litigations, enforcing your patent, and so on? And then maybe you need to think about what is the value for your company owning this, or would the value be bigger for somebody else owning this? So maybe it's not your company who is able to license it, but somebody else who gets most of the value. And then kind of you take it from there. And this is very commercial, market-based type of thinking for patent licensing. And then just shortly, I don't want to take everybody's time, but with regard to technology licensing, this is different because in pure patent licensing, the patent knowledge and the teaching of the patent is there. It's public and publicly available, and then it's the patent owner's right to exclude others if they want and if they can. But for technology, there is something that the licensee typically would get, a deliverable that enables, for example, new features for your product, or faster time to market, or cheaper production cost, or higher premium that you can charge with the technology assets that you actually get with the deliverables. So typically, technology license is not patents only, but they may also include other technology assets that are not otherwise available or publicly available at all. So then the valuation is a little bit different there, because there are also other things than patents that you may need to have a different valuation. I would start them on the kind of the market-based approach, commercial approach, as I explained. but there are the other elements. For example, many of these technological elements may contain trade secrets, and trade secrets is something, a piece of data or information that is not publicly available and which is adequately protected from being publicly available, and it has value because of that. So what could it be? One could, in theory, develop the same data or information or know-how independently, but it may take years and it may take a lot of money to invest into R&D to get there. So would it be easier to just pay to avoid the costs and to get there faster? Then what is the value of that trade secret, which is also IP? But so that's kind of a question in technology licenses. These technological assets can also be like databases. They can be copyrighted assets, which are needed, for example, to use the technology. So that patents are not necessarily enough, like in our case, it's not enough. And these may be very hard to value. So the valuation for license would again come back to the value of technology and the technology assets that may contain patents and trade secrets and know-how and copyright matters and so on. And then eventually it comes down to what the licensee can pay or what the licensee is willing to pay. And they need to think about, of course, their licensee's own technology position. Are there alternatives for this technology? Can they absorb the price of the price of the license into the price of products? What are the margins? What is the market like? And so on. So, but I will stop here. So kind of all in all, there may be a great IP that doesn't have market value at all, even though it's great technology. So it depends on context.
So, Sonja, great. That was a great primer, sort of a good overview of at least. You covered a lot of things, contextual, which I agree. You have to know who you're licensed it to, the market, and everything like that. And then you talked about a strict patenting license, when it comes to standard essential patents, and then technology, which would be really technology that is not covered by a patent. And I always think of trade secrets, which you mentioned. So those are definitely three areas. But I think it was an understatement when you said that technology can sometimes be hard to value. I would say that is probably the case in all kinds of IP, whether covered by a patent or technology or in context. But thank you for sharing that with us. And I'm going to come back to you, maybe ask you something about a real life situation you were in, where you went in one of these three categories and how you fared. I'm going to move over to Abdullah. Abdullah, you're out of Saudi Arabia, and tell us a little bit about yourself and what you do and your experience and background, and maybe a transaction or occurrence where you had to value IP, and what did you do and how did it go? Oh, Abdullah, I think you might be muted.
Thank you very much, Patrick.
Yeah, there you go.
I'm glad to be here. I'm currently working at Saudi Telecom company, which is the largest mobile operator in the MENA region. And we've expanded into different sectors within the technology ecosystem and outside of that ecosystem as well. And I've worked in different industries. I started off in petrochemicals, and then I went into real estate development, and then I joined the Saudi Stock Exchange, and now I'm at STC. I work in the legal, more of the corporate governance side as of recently, and we work on board-related strategic issues, and surprisingly or not, the strategic considerations sometimes involve IP matters. And in terms of transaction or IP initiative, that I've been involved with. There was one where we conducted an IP audit of one of the organizations that I used to work for. I can't disclose it for confidentiality reasons, but we conducted a top-down audit of anything and everything that you can imagine that would be classified as intellectual property. That goes from trademarks, logos, um, uh, any technical knowledge, trade secrets, and even some music. The organization that I'm alluding to used a lot of music for its public relations campaigns, special short sequences that I didn't expect it, but they were deemed as IP assets as well. And interestingly enough, that had an effect on the value, because we conducted a valuation of the entire portfolio, and that was an interesting exercise because of the differing types of IP assets. So some IP assets were uh, the ones that were considered for technology transfer were valued in a certain way, and other assets that were used for licensing purposes were valued in another way. So that was interesting. It was a bit controversial, just because there are different stakeholders involved within the organization. So some departments consider themselves owners, operationally at least, not legally, of a certain class of IP assets. And there were also debates as to which methodology to use. For those who aren't aware, the three common methods, and please feel free to add any input on your side, but in terms of valuing intellectual property, you have a cost-based valuation, a market-based valuation, and an income-based valuation. And these were all relevant in our exercise. So for a cost-based valuation, you take into consideration how much the asset cost to create and how much it would cost to create, taking into consideration current rates. So the market economy can have a direct impact on the valuation of that class of assets. But then you go on to a market-based perspective, which looks at different types of transactions. So here we're talking about assets that can be transacted upon, whether by sale, purchase, license, uh, uh, to arrive at a conclusion of value. And the third and final methodology is the income-based valuation, which, as the name suggests, uh, considers the stream of income which is attributable to the IP asset. And there you look at you use a sort of P&L scenario, profits and losses, by examining historical earnings and predicting expected future earnings. So it was a very interesting experience. There's a lot of strategy. There was a lot of PR involved, and obviously pure IP law, a lot of accounting aspects. So we worked with different stakeholders, and we came out with a valuation, which we didn't act upon, by the way, but it was an important exercise for the whole organization, just to know the value of what we own. Because prior to that, we weren't really sure, and it wasn't taken into consideration. And interesting enough, the idea of this IP audit was driven by the marketing team. It wasn't recommended by lawyers or the finance team or the audit team or the board. The marketing team recommended, because they operationally they owned much of, or managed much of the high value assets.
Abdullah, that's a huge undertaking to go through an organization and say, okay, we're going to try to identify every piece of intellectual property, and then when we identify it, then we're going to put a valuation on each piece, and then with each piece, there's competing interests on what methodology to use to how you value that. So it seems to me that undertaking is monumental. And I can understand some of the reasons why the people in your organization that were non-marketing, that said, why are we going through this exercise? What's the purpose? It seems like a huge amount of work to what end. But actually, I would say that if you look at a lot of people talking about IP valuation, there's a lot of organizations out there that like-minded are trying to come up with some standard accounting practices on how to evaluate IP. So we have when you use a certain method, like you talked about, everybody be using the same method, across the globe. But so what did you find out when you finished it? Did you find out if you added up all the valuation of this IP, you found out that your organization was some percentage X more or X less than what you had before you did it?
It was it was a great surprise, or great finding. We found out that there was at least because we also had to take certain market conditions into consideration, at least a 7% increase of the total value of the organization. And it was a publicly listed company. So that was promising, but it wasn't announced.
Yeah, it has implications.
Exactly.
If you go out and announce it, we're worth 7% more than we thought, then you invite a lot of people to come in and take a look at what you actually did to get to that extra 7%.
Exactly.
So I understand.
Yes, it might affect there was an argument that, yes, let's push the share price, but then there was a debate, a concern of potential shareholder activism. Some investors will say, why not divulge these assets? Why not license them and try to get involved in the strategy? And that would just create conflict that was deemed unnecessary at the time.
Back to the session title, How to Value Our IP. It's kind of like how should I do maintenance in my home? It's like, okay, I'm just going to call up somebody and have them come in and do it. So you bring up a good point. When you value IP, you can actually do it in-house yourself, or you could maybe hire an outside third party to come in and do that work for you. Sonja, I'd like you to comment on what you think about inside or an outside valuation. How to value your IP. Should you do it internally? Should you hire a third party? But I'll first throw this to Abdullah. In your case, was this all done internally by your own financial people, accounting people, marketing people, or did you hire somebody outside to do it?
Initially, it was conducted internally, but some of the stakeholders wanted to prove a business case or enact a business case. So they knew that there was an internal process where that business case would be challenged. So to support their business case, it was deemed necessary to hire external counsel. And when I say external counsel, I mean that in the broadest sense, and I'm not limiting that to lawyers. Yes, a firm, actually 2 firms with legal IP experience were hired, but there were also management consultants. There were also financial and tax advisors, as well as a public relations firm.
So you had really sounds like an army of people come in and look all over the things, and that basically was to confirm some of your internal findings. Sonja, what do you do? I mean, I'm sure there's a mix of both when you're valuing an IP. What considerations do you undertake, or what some of the things that motivate you to just keep it inside or go outside to a third party?
That's an excellent question. Thank you for that. I think that sometimes there are situations where you pretty much have to go to outside party because, for example, if you are working in a growth company, if you have a growth company that has IP in there, and obviously, for example, before M&A transactions, you need to have some kind of a value, and it may be that your board wants you to have valuation of your IP because they want to understand the company value. Obviously, the transaction or let's say acquisition, for example, it may or may value of IP may or may not have real impact to the actual market situation where your company is acquired. But if you have an outsiders, let's say outside counsels, and kind of patent evaluators and IP counsels opinion on the value of your IP, then it may be easier to communicate to the potential acquirers the value of your IP to the company. And then my tip would be that if they don't recognize the value, if the acquirer doesn't recognize the value of IP, then if you are able, don't include it in the sale. Just spin it off and treat it differently if the value is not recognized. But in this kind of situation, you have to go to outside because your internal evaluation obviously wouldn't be something that can be communicated. And in such a situations, you must go to outsiders. But then if we take one of those examples that I had, that we're trying to create a licensing program, for example, then outsiders don't necessarily help you in creating the program. You have to find out the market commercial valuation points yourself. Maybe you can find help for that, obviously, but you probably know your technology and your markets better than the outsiders. But then you need the outsiders or outside counsels again if you, for example, need to enforce, because obviously your own opinion in the litigation wouldn't count as much as, or it would be one opinion, but you would need to get some strength from outsiders' opinion. So I would say that again we come to the context on what are you trying to achieve, and then inside or or outside counsel's opinion would matter.
Yeah, certainly. If you do it, if you do the valuation internally, you have the benefit of probably saving some costs. But the other hand, some people might point out your valuation and say, well, it's self-serving. Of course it's that high, or it's, especially if you're in litigation, you're trying to prove damages, and you say, look, we did the evaluation ourselves, and came out to be, $25 million. And yes, of course it did, because it's self-serving. If you
Of course.
went out and get a third party, they came in, there's a lot more credibility that, hey, I just followed the numbers, I followed the methodology, and this is what I came up with, and there's no self-serving interest. But outside evaluations, would you say, Abdullah, when you hired some of these third parties to come in and do it, you probably had quite a price tag along with those experts that came in and helped you do this, right?
Absolutely.
Yeah.
Absolutely. It wasn't a cheap exercise, but I don't think anyone was surprised, um, and we didn't really have a choice, because we were fortunate that we had resources to contract with the best of the best in that domain. But it wasn't so much as cost for us as it was uh, playing the role or wearing the hat of project manager, because you have to understand that internally, uh, each department that managed some of the assets, uh, you know, in a lot of cases, they treated the assets as their own property as a department. So there was a bit of tug of war in that sense, and we decided to establish. Now we're talking about governance of an IP audit. We set up a steering committee to manage this process, and we had to, identify some accountabilities that were applicable to anyone who had any form of decision making authority on the use of these assets, or any visibility on any information pertaining to these assets. So there was a project management, corporate governance, and simple as this, lots of office politics.
Well, you brought up a good point, Abdul, about governance, and I don't mean to interrupt you. I'm sorry. We are running out of time, but I think good corporate governance around your IP policy, the valuation, how you do it. I mean, for instance, Sonja, I don't know what it's like in your company, but if you have a patent that you're paying annuities on in a certain jurisdiction and you want to abandon that patent, it's a company asset. And who knows what the value might mean to the company. You say, well, it's been sitting around for years, we're not exploiting it, this and that, and you abandon it, and all of a sudden you find out there's 3 market players playing in that space for the patent. They were just waiting for you to abandon it or get rid of it and come with that obstacle. So simply abandoning a patent in what seems to be an obscure jurisdiction would be something that you should set policy around, and something that has visibility and a methodology to know what you're doing. And sometimes you'd have to do evaluation around a patent if you're going to decide to abandon it in a certain jurisdiction. Would you say that's true, Sonja? Do you find yourselves when you're managing that patent portfolio, how you whittle it down? There's a lot of process around it, a lot of concern.
Yes, I think that's an excellent point again, and I think this is present for all patent owners. Everybody is under some kind of a resource constraint and need to do these kind of decisions strategically, and I if you should know or the value of your own patents and which patents are in the core technology, which might be something of not in the core or not that important technologically, for example, because not every patent is valuable beyond measure. So if you have your crown jewels, you would probably be much more considerate in abandoning them. If they are something that is not necessarily in the core of your technology, then maybe the decision is easier. Then kind of a commercial point of view, we are living in a very, very global world still. If you think about protecting your patents in those jurisdictions that at least sorry for the echo. So that at least making or using or selling the technology covered by your patent would be in a jurisdiction that you have protected. Then in a global world, you usually, even with the kind of let's say more restricted patent filings, you could have sufficient coverage, but then the less coverage you have, the more important the geography is, of course. But if you said like obscure ones, so but be careful with that.
Yes,
strategic decision.
Right, you have to be very careful, and I guess the message is, you know, have a policy around it, and you don't want to be operating ad hoc for, you know, how you manage your patent portfolio, what you decide, how to extricate yourself, and what you find is no longer strategic to your company or not. But you should have a set policy around that instead of just leaving it to someone to decide arbitrarily. Now, I think we're running the end of our session. We go until 2:50. Is that our understanding, or do we go to 3? Do you know, Sonja?
I think it was 2:50.
Yeah, it's still 2:50.
Okay, so we're right at the end of our session, and I'm not really sure how to end this, except, you know, I will say that there's a lot of methodologies used out there, and Sonja shared us a lot, and so did Abdullah. If you're going to do or get IP valuations, one of the best things to do to know that you probably have the right numbers, use two different methodologies. Have two different methodologies, and where they converge is probably the right number. I'll finish with that. I'll thank our panelist members, Sonja and Abdullah, for joining us. I think you shared a lot. You really gave us food for thought for everybody to take away and say, wow, I need to know a lot more about this.
Thank you. Thank you, Patrick, and thank you, Sonja.
Thank you, Patrick and Abdullah.
Hi. Thanks to our speakers. Thanks, Patrick. Thanks, Sonja. Thanks, Abdullah, once again.
Okay,
so
very good.
Before we finish this session today, I would request our speakers to smile and look at the camera for a second so that we can capture the moment.
Okay.
All right. Thank you so much. If there is any question, the floor is open right now. All right, I guess we don't have any question for this session. So thank you all for joining us for this event for day 1. I hope all of you had a good time, a good learning experience as well. And tomorrow I would request everyone to join us at 9 a.m. Eastern Standard Time. So that time we'll start our event again, and hopefully you have a great day ahead. Thank you all.
Thank you. Bye-bye.
All right, bye.